tonight. I knew Lex since 1998. We met the first time at the Institute of Law of Birzeit University, where I was still a student of law and researcher at the institute at that time, and we were happy to listen to his lecture at that time. And also, I knew him through his first edition of the book, where I consulted several times in my PhD. Of course, I had some disagreement, some points of disagreement with him at the time, but that is the nature of the academia. Our second speaker is my friend and colleague Francesca Albanese. Francesca and I worked for a couple of years at the Office of the High Commissioner of Human Rights in Geneva. She also worked in different locations, and now she's a full-term researcher at the Georgetown University, and she's spending most of her time conducting research relating to the issues of human rights and refugees in the Middle East, particularly Palestinian refugees. So welcome, Lex and Francesca, or say few the objective of this webinar. Of course, we are talking about, we will mainly review the book or speak about the book. But again, we are a long-standing issue of the longest refugee problem that is still alive in the world, which is the question of Palestinian refugees. Of course, the time of this webinar will not be enough to discuss all what Francesca and Lex wrote in the book, which is over 600 pages. But we will tackle the main issues, and we will try to answer a number of questions. So, first question that we would like Lex and Francesca to answer is what is the position of international law regarding Palestinian refugees in comparison with other refugees? So is there a protection gap with regard to Palestinian refugees under international law, and what is that gap? And what, in particular, the 1951 Refugee Convention talks about Palestinian refugees? Is there a special regime for Palestinian refugees under the 1951 Refugee Convention, and how that impacted the status of Palestinian refugees in various host countries, in particular in the UNRWA areas of operation in the Middle East or in the Arab world. We also would like to hear from Francesca and Lex some words about the crisis in Syria, and how the Syrian war has affected the rights of Palestinian refugees. Talking about the future, we would like to also hear a few words about the prospect for just solution for Palestinian refugees, and the question of naturalization of Palestinian refugees in some host countries, and what would be the effects of the acquisition of a new nationality on the status of Palestinian refugees, and in particular the right of return. Of course, Francesca and Lex are expert on this, and we'll also have time for our experts in international law who are with us via Zoom, Jurists for Palestine, also to pose their question. Just last minute about a few remarks about the book. I followed Francesca and Lex in the process when they were preparing the book, and I was happy to receive a copy of the book, and I read several parts of it. I would not claim that I read all of it, but the general impression is that this book is probably the most comprehensive work on Palestinian refugees and international law. It is comprehensive in terms of time. So it addresses the question of Palestinian refugees right from the beginning. I say from the moment when Palestine was separated from the Ottoman Empire, and when we started to have an entity that is called Palestine, when it was occupied by Great Britain, and later when it was placed under the mandate, and how that affected the issue of Palestinian refugees until, of course, today. And it is comprehensive in terms of geography, meaning that this book covers the situation of Palestinian refugees in various parts of the world, in all continents, in many countries about the world, in the world. So that is the main characteristics of the book. Of course, this were written, were researched, based on, I would not think of any or any document related to Palestinian refugees being treated or case law decisions of courts or policy papers or UN decisions. All these documents were consulted by Lex and Francesca. So we are today or tonight hosting the most expert in this. Lex will speak.
Thank you.
And then we'll give Francesca another 15 to 20 minutes. And then we'll, Lex again will speak for another 5 minutes to have some concluding remarks before starting our discussion and taking questions from our experts in the Zoom, Jurists for Palestine. So I thank them very much for being with us and being ready to ask questions. And also, finally, I would like to thank our interpreters who are doing also great job, Noor Haqqi and Malik Diraniya. Next, you have the floor.
Thank you very much, Mutaz, for your kind words of introduction and also for your comments about the book. It's a great honor for us to have this opportunity for a conversation with all of you today. And let me begin by thanking our friends in Law for Palestine, and in particular Isan and Hassan, for organizing the event, for you, Mutaz, to agree to moderate the discussion, and to all of you through the different platforms joining us today. Very, very happy to be with you. When I wrote the first edition of this book, and Mutaz, you already made reference to it, it was originally my PhD thesis. I wrote it mostly in Gaza in the 1990s. And at that time, there was already lots of literature about the Israeli-Palestinian conflict, including legal works, but very little specifically about the people at the heart of the conflict, the Palestinian refugees. As a young lawyer, working with the Dutch Refugee Council first, and then with UNRWA, the UN agency, as you know, for the Palestinian refugees, I had considerable difficulty in understanding why Palestinian refugees were the only group of forced displaced with a different treatment to other refugees under the international refugee regime. The book I wrote in 1998 was the first attempt to comprehensively analyze the various legal aspects of the Palestinian refugee question and their distinct status in international law. The first edition, written at a time of the Middle East peace process, reflected the optimism of the time, including the expectation of the establishment of a Palestinian state, which many believed would help resolve the refugee question. This optimism proved unfounded, and almost every political development since the Oslo breakthrough has adversely affected Palestinians, both those under the yoke of the Israeli occupation in the Gaza Strip, the West Bank and East Jerusalem, and the refugees at large. One of the few positive developments brought about by the Middle East peace process has been the increase of legal literature and research on the Palestinian refugee question by scholars and practitioners and Palestinian refugee organizations like Badil. However, this new research focuses on either the situation of Palestinian refugees in specific countries, for example, Palestinian refugees in Lebanon or in Egypt, or on their specific rights, such as the right to return and the right to compensation, or on the protection gap affecting Palestinian refugees owing to the exceptional regime embodied by UNRWA and the UNCCP versus UNHCR for other refugees. An updated analysis of the Palestinian refugee question as a whole, looking holistically at historical, legal, and political aspects, continue to be missing. Also, at a time of increasing attacks against UNRWA, which disingenuously included attacks against the very existence of Palestinian refugees, the difficulty of researching UNRWA for people who had not experienced it from within was an obstacle to fully appreciate both challenges and opportunities of the regime set up for these refugees. So whilst continuing to work with UNRWA, it gradually dawned on me that it would be important to update the book. As I dreaded having once again to embark on years of solitary confinement to accomplish the task, I decided to look for a co-author. That turned out to be a complex undertaking, as I needed a good international lawyer with a solid understanding of the question of Palestine and the Palestinian refugee issue, but also an excellent researcher and networker, as there was lots of new literature and many more were engaged on the issue than 20 years ago. Last but not least, I needed someone with their heart in the right place. Having worked with Francesca during her tenure at UNRWA, I felt that she might fit the profile. Though it took patience and perseverance to convince her to accept my proposal, she rapidly proved to be the perfect choice. Not only did she agree to be my partner in crime, she also accepted to act as the principal author, taking the lead in the drafting of what essentially became a new book, reflecting the wealth of developments and knowledge that we were able to tap into. For me, the experience was totally different than the mostly solitary exercise of writing the first edition. My role this time was to offer strategic support, to brainstorm with Francesca on how to tackle legal and other dilemmas we encountered on the way, to review the various drafts, but also to tap into my extensive network of academic and other contacts relevant to the book. The result is a much better, much richer book. As she has been the lead author, it is only fair that I ask Francesca to present the book to you. Francesca, the floor is yours.
Thank you, Lex. And let me echo you in thanking the organizers for this splendid opportunity, for this splendid event, and Mutaz for being the moderator. And yes, greetings to everyone from Indonesia, where, as you can see, it's full night. Let me start with something personal as well. Lex mentioned that I was initially reluctant to engage in this project, which is true. Having worked with UNRWA and the Palestinian refugees, I knew that the new edition of Lex's book was much needed. But the reason why I was not enticed at the beginning is that I knew it would have been a daunting task, and yes, it was. The other thing is that as a human rights lawyer by training, I felt more confident as a user of academic research rather than one producing it. And deep down, I also feared that embarking on a research on a matter on which I held some quite strong personal view could compromise my objectivity and my legal rigor. And then, of course, this proved unfounded. But what ultimately persuaded me to accept Lex's proposal was something that I had experienced as I was working with UNRWA in the Department of Legal Affairs for a few years in Jerusalem and after leaving UNRWA. And is the fact that there is no shortage of misconception on anything concerning UNRWA and Palestinian refugees. And more than that, how toxic has become the debate surrounding Palestine and Palestinian refugees over time, especially in the West. The mantra is that Palestinian refugees are not legitimate refugees, the right of return is pure fantasy, and UNRWA, the United Nations Relief and Work Agency for Palestine refugees, is part of the problem and continues to serve refugees who should have already been naturalized wherever they reside. Because of course, Israel has nothing to do with that. So those claims that have only grown stronger over time, in my view, I mean, already when I was with UNRWA, I had the perception that they served a political purpose, distracting from the reality that ending the de facto indefinite refugee status of millions of Palestinian refugees requires political solutions in line with international law. The failure to find such solution is what causes the existence of the Palestinian refugee questions and the growing numbers of them. Certainly not UNRWA. UNRWA stands as a symbol of a political deficit, nothing else. And so I realized that a honest and conducive debate on Palestinian refugees and UNRWA was still needed. And having worked with UNRWA, I had the instrument to unpack some of its crucial issues that are not necessarily intelligible from outside. So the other thing is that it was necessary for us to insist on the full picture of the Palestinian refugee questions from the origins to present day, because this is central to the whole question of Palestine. And there is a need to disentangle the refugees and their future, their fate, from the framework of the two-state solutions, the territorial solutions to the so-called Israel-Palestine conflict, to which they have become so closely, even though invisibly, associated with. So it's with this spirit that I got eventually convinced to become what Lex calls his partner in crime. And this is why I'm here. So for this audience, I probably don't need to spend many words clarifying who Palestinian refugees are, but just for the benefit of those who are following us and might not be fully familiar, is that we will refer to them as those who were displaced in connection with the creation of the State of Israel from 1947 onward, 1949, and through the 50s, which constituted the majority of the indigenous population of historical Palestine, and were never allowed to return. 750,000 back in 1948, over 6.5 million today, most of them registered with UNRWA. But then there is another group, those who were displaced in 1967 with the expansion of Israel's Israel's control over the West Bank and Gaza after when the occupation started of the West Bank and Gaza, which caused 400,000 displaced, which are now over 1 million, some of them served by UNRWA. So historically, Israel's denial to allow the refugees to return to their homes has produced an undermined resistance of Arab states and Palestinian refugees themselves to embrace other solutions. But the reality, in fact, is that now we have the largest group of refugees worldwide, numbering over 7 million, the majority of whom are stateless, so living like Lex said in 1998, without the right to have rights, so sort of in perpetuity. So this is why we decided that this book not only had to look at the question of Palestinian refugees as a as a legal problem, as Lex had done in the first edition, but had to follow the diaspora, where it had gone, because it has grown much larger than we tend to think, like a refugee problem that is confined to the Middle East, as I will have the chance to explain in a minute. So we have no illusion that international law per se doesn't provide an easy solution to the Israel-Palestine situation, but still we think that it's necessary to use it in a sort of counter-hegemonic way to challenge the current state of affairs and contribute to inform a principled political dynamics in the direction of justice and hopefully peace, and meanwhile empower the Palestinians in exile. So what our book is about from beginning to end is, as Mutaz mentioned, is provide a comprehensive overview of the Palestinian refugee question through a legal dimension, but bringing political and historical aspects in the discourse. And so rather than describing in detail what the book is, I would like to take you through the main takeaways, also bearing in mind the questions that have been shared with us at the very beginning, which Lex and I will try to respond to answer as we present the book in the next 15 minutes or so. And if questions remain, we are very happy to elaborate. So first of all, the first takeaway of this book is that compared to the first edition, this new version engages in a deeper and more organic legal exploration of the events that befell Palestine and its people from the last days of the Ottoman Empire, when political Zionism laid its ambition on this land, and through the decades of British mandate, which paved the way to the unrest which trapped Palestine from 1947, 1949 onward. This was triggered by the UN partition plan, and that, as you know, led to unrest and then a full-fledged war. And this is what provoked the massive exodus of Palestinian refugees, 2/3 of the indigenous Arab population of historical Palestine. And we also look at what happened through the Israeli occupation of what remained of Palestine in 1967 till present day dispersal of Palestinians around the world, in the Middle East, in the areas where UNRWA operates, but also in Europe, in North America, South America, and increasingly in Asia, Southeast Asia, and Africa, and I'll return to it. So in a way, the book offers the most complete picture of the Palestinian dispersal around the world. Lex and I were able to survey over 2 years, 60 countries, and per each country, we have discussed waves of arrivals, numbers of arrivals, and different status and treatment within the national context, historical context of Palestinians in each of these 60 countries, which also shows the level of discrimination that different groups of Palestinians experienced in each country, based on their faith, based on their political affiliations, based on the time of arrival into host countries. Now, looking at the present, and this makes me also think of answering the question regarding how the Syria war has changed the reality of Palestinians, of Palestinian refugees. The lack of proper recording of Palestinian refugees in national system often makes them statistically invisible. And this is something that has become extremely clear with the Iraqi war and with the Syria war, which have provoked an exodus of Palestinians among the other that were displaced from both countries. And in both of these situations, Palestinian nationality has not always been captured. And when I say nationality, I know I'm speaking to lawyers, but I'm also speaking to people who are mostly from the Arab regions, who are familiar with the fact that nationality has a in ethnopolitical terms has a different meaning than citizenship. And so this is when I refer to Palestinian nationality, I will say nationality instead of citizenship. So and not only Palestinians are not necessarily captured, which has implications on their the protection that is accorded to them, and I'll return to this in a minute, but also it provokes a sort of loss in tracking where the diaspora is going. So, but looking at what has happened from 1948 onward, we note that there is a continuity of Palestinian dispossession and displacement that happens not only from Palestine, but there have been 700,000 Palestinians displaced from the Arab world from the 1970s onward, from Kuwait, from Iraq, from Libya, now from Syria, and in other countries in the Gulf. And not only in connection with wars, but also in connection with changes in refugee policies, with changes in migration policies, with this overt discrimination against the Palestinians, and sometimes outright persecutions. This is, 700,000 is a new Nakba, and this is happening as we speak, continues to happen as we speak from the Arab region. And so where is this continuous displacement ending up? As I said, in recent years, Europe and the West in general has become more and, let's say, less and less welcoming toward refugees in general, but including Palestinian refugees. So Palestinian refugees now displaced for a second and third time over their lineage, end up in places like where I live, in Indonesia, in Malaysia, in Thailand, after living all their life in Iraq or in the United Arab Emirates, because they're no longer secure. Their residence permits are being withdrawn. So this is something we should be very careful of. The second issue is that this book, and this is very important, provides a new critical analysis of the distinctive regime set up by the United Nations for Palestinian refugees within the international refugee framework. I know that lawyers and in general scholars tend to think of Palestinian refugees as an exceptional group, but the point is, Lex and I have made the effort to think them and think of the way the Palestinian refugee question was born against the background of the forming of the refugee system, and all makes sense because even Article 1D of the 1951 Convention, which is normally, is one of the most misunderstood international law provision I've ever come across, but it's also one which is largely interpreted as excluding to core Palestinian refugees from the protection of the international refugee regime. Actually, this is not the case. Article 1D stipulates a different set of arrangements to protect Palestinian refugees that made sense 70 years ago when the 1951 Convention came into force. And back then, bear in mind, ad hoc solution to refugee crisis were the norm, not the exception. So the 1951 Convention came into force when the United Nations had already decided that the Palestinian refugee situation would be solved through the United Nations Conciliation Commission for Palestine, UNCCP, which was supposed to solve the Palestinian the overall question, the overall conflict in Palestine, including the refugee issue. And also disposed that the UNCCP would oversee the return of the refugees willing to return and resettlement and compensations of those not willing to return. Because negotiating peace proved uneasy for UNCCP, UNRWA was created to systematize the much needed aid and relief to Palestinian refugees. And this is the system that the 1951 convention captured, said, because there are already these bodies dealing with Palestinian refugees, UNHCR, which back then was supposed to be the body dealing with refugees from Europe, the 1951 convention was supposed to be the convention for refugees from Europe, not the universal instruments that are today. This is why there was no reason to duplicate. But Article 1D recognized the international status of Palestinian refugees in international law and said, until this group of people is protected by these agencies, they won't benefit from this convention. But the moment this protection and assistance ceases, they will be protected. Exclusion means exclusion from UNHCR system, not from the rights of that the convention has in mind, and this is fundamental. So the third question is that we apply an overall approach, a wholesome approach of international law to Palestinian refugees, fighting that tendency of international lawyers to become more and more specialistic, saying there is international human rights law, there is international humanitarian law, stateless law. This is all good and valid. But the point is that these refugees wear different hats. And so we try to, per each situation, offer a comprehensive analysis, looking at the protection they are entitled to in line with all these bodies of law. And in this spirit, and this is the fourth issue I wanted to tackle, we look at how international law as a whole can be useful for Palestinian refugees, and including all developments that have occurred in the field of international law. This doesn't concern the right of return, because for us, the right of return existed already as an established right in 1948. It's not created by Resolution 194. Resolution 194 just reaffirmed humanitarian law and principle of how to solve, how to address international wrongful act, and how international law sanctioned the denationalization en masse that the Palestinian refugees had suffered. So, based on the rights as it stood in 1948, Palestinian refugees were entitled to return as illicit citizenship in Israel if they wanted, and regain possessions of what they had left behind. This right has only become stronger over generations. But apart, this also means that they are entitled to the protection that is offered by international law, including citizenship. Yes, to answer the question that was raised in the beginning, Palestinians should not be precluded to apply for citizenship where they are. Would they relinquish their right of return? No. The refugee status under the 1951 convention is brought to a cessation when there is an acquisition of citizenship, no doubt about it. But the protection Palestinian refugees are entitled to is broader than the refugee status. It entails returning to their original homes, being entitled to restitution, and being redressed of the injustice they suffered. And for this, and this is my last point, we also proposed an application of a holistic application of international law to solutions. We suggest a comprehensive framework for rethinking solutions for Palestinian refugees based on involvement of Palestinian refugees first and foremost, a participatory multi-stakeholder approach, and which take off the weight from the, let's say, Israel only as a decision maker, and again puts the rights of the refugees at the center of the discussion. I would stop here, knowing that Lex would like to have some final remarks, and then hoping to continue the discussion.
Lex, please go ahead.
Thank you, Francesca. Yeah, let me conclude. I mean, Francesca has, already addressed most of the questions. So let me reflect a little bit on our ideas with respect to durable solutions for Palestinian refugees. We argue in the book that the 2016 New York Declaration on Refugees and Migrants provides a unique opportunity to also re-engage the discourse on solutions for Palestinian refugees. The declaration, unanimously adopted by the UN General Assembly in 2016, in response to the largest refugee crisis since the Second World War, you will recall the big refugee crisis in Europe, provides a powerful political reaffirmation of the international refugee regime that was put in place after the Second World War and subsequent decades, including the centrality of international law in protecting the human rights and fundamental freedoms of refugees, and the approach in promoting durable solutions for refugee situations. The declaration underscores the importance of a systematic and comprehensive response in addressing refugee questions. It calls, amongst other things, for the development of a so-called comprehensive refugee response framework for each large-scale refugee situation, including protracted ones. These comprehensive refugee response framework are to be developed through a multi-stakeholder approach, with a key role for national and local authorities, international organizations, international financial institutions, civil society, and last but not least, refugees themselves. It also calls for addressing all aspects of a refugee response, including root causes, ending refugee status and statelessness through a combination of durable solutions and humanitarian assistance. Now, the New York Declaration applies to all refugees, including Palestinian refugees, as appears from a number of references in the declaration to UNRWA. In spite of this, to date, no such framework has been developed for Palestinian refugees. And we suggest in the book that this lacuna be addressed at the earliest opportunity, with UNRWA and UNHCR facilitating the process together, each with respect to the Palestinian refugees for which it is responsible. We believe that a comprehensive response framework for Palestinian refugees, developed under Palestinian leadership, including refugee groups and diaspora networks across the world, has the potential of ending Palestinian exceptionalism and allows for a 72-year-old refugee question to be approached anew with a state-of-the-art 21st century toolbox. You may wonder what such new framework would add to the multiple peace efforts that have been undertaken since the late 1940s, or how it would be different from them. The answer is in the very elements of a comprehensive response framework for Palestinian refugees, as well as in the process of its development. So let me begin by the first. Here are what we believe some of the key elements of a comprehensive response framework for Palestinian refugees. The framework should first and foremost reaffirm the legal regime applicable to the Palestinian refugee question, comprised of the relevant norms of international law, including the relevant UN resolutions, specifying their meaning and implications. This addresses the first element of what we feel is necessary and paves the way to a rights-based discourse on both protection and solution, reconciling the rights to return to the right to apply for citizenship in other countries, which has been absent way too long. And Francesca has already made a point that acquisition of citizenship or asylum in certain countries, including countries in the West, does not jeopardize the right of return nor the related historic claims of the Palestinian refugees. They flow from the historic injustices perpetrated against the Palestinians. The New York Declaration underscores the importance of addressing the root causes of any large-scale displacement. And as such, the development of the framework for Palestinian refugees could provide a setting, an entry point to initiate under the UN aegis public discussion on the Palestinian refugee question. This would include both its origins and constituting elements, the past, as well as the broader context of the unresolved dispute between Israel and the Palestinians, the present, and in particular, the unresolved question of self-determination. Thirdly, addressing the Palestinian refugee question within the framework of international law means aligning the search for solutions with international refugee law and practice. The combination of the durable solutions has helped resolve other protected refugee situations and could help do so for Palestinian refugees as well. And once again, this would not mean relinquishing the right of return, but create a basis and a space for the refugees themselves to discuss its significance whilst exploring solutions more holistically. Finally, the framework will have to address the important issue of restitution and compensation, on which there has been little progress despite the incredibly important work by the UNCCP in the 1950s and the first half of the 1960s, and other technical experts to evaluate property left behind in 1948. Then let me turn from the content of the framework to the process of its development, which is equally important and bringing a novel dimension to the discourse. As I already mentioned, the New York Declaration calls for a multi-stakeholder approach. In the Palestinian case, this would require the mobilization of a wide and diverse front of supporters of the framework, including the UN, host countries, both in UNRWA's area of operations and other countries that host significant numbers of Palestinian refugees, donors, and civil society. The Palestinian political leadership and the refugees themselves must have a central and leading role in this process. It should entail consultation at the national, regional, and international levels, structured engagement with refugees in host countries, and exploration of the feasibility of various solutions and other measures. To conclude, we have no illusion that it is going to be an easy journey, but we believe strongly that this approach would give new impetus to international action in favor of Palestinian refugees and their right. And this does not need to await and could help advance a more positive outlook for the wider political process. Thank you, and we would now be happy to answer your questions.
Thank you, Lex and Francesca. Amazing how you could summarize this very, very complicated and big issue in just about half an hour. That's really what we were expecting. And it's also amazing how you could merge both the technical issues with presenting them in very simple way that we could be understood by both experts and by the general audience. Now we'll open the floor for our jurists to pose questions. But just me, if I may take advantage of my role as a moderator to ask two questions. One to Francesca, taking over from what Lex said regarding the New York Declaration. The main problem, as you know, with regard to Palestinian refugees is the question of enforcement. And this issue has been there, the issue of refugees for about 100 or over 100 years. But now we have the possibility of having the ICC, the International Criminal Court, taking over as it was decided on the 5th of February, that the court has jurisdiction in Palestine. How that decision of the ICC might affect a question of enforcement with regard to Palestinian refugees, taking into consideration that this issue is an ongoing or continuing crime in terms of time. Of course, it started a long time ago, but after 2014, when the court has started its jurisdiction in Palestine, still we have the question of Palestinian refugees and the non-return of Palestinian refugees. And also continuing in terms of space, because refugees were displaced from Israel, which is non-member state to the ICC, but they are in Palestine, which is a member state, also in Jordan and probably in other countries. So this question is to Francesca. My question to Lex is regarding the new policy of the United States regarding the funding for UNRWA. One of the conditions that, or the conditions or terms that the US is negotiating with UNRWA is the question of reform, UNRWA reform. Having worked for over 30 years with UNRWA, in your view, what are the main reform points or issues that UNRWA should undertake? For answering my questions, I would like also to open the floor to take another maybe 2 questions, and then continue. Give you maybe a few minutes to answer them, and then take another bunch of questions. So the floor is our probably Imran. Imran is trying to ask. Imran.
Yes, I can see, Dr. Mutaz, a question from Hassan, Imran, and a question from Hiba.
Okay, Imran and Hiba. And of course, you can ask both in Arabic or English. If you speak in Arabic, I will translate it into English. Imran, Fadal, go ahead.
And thank you, Francesca. Sorry, it was muted. Thank you, Dr. Mutaz, and thank you, Francesca. Thank you, Lex, for your amazing lecture. As Dr. Mutaz said, it's quite amazing that we could summarize all this in this short time. I have a quick question. It's about a new proposal that has been, I don't know if you heard of it. It was it came to public quite recently, that Palestinians could give some sort of citizenship to the Palestinian refugees outside. I mean, the Palestinian leadership, the Palestinian state or the authority, if we can say, if they provide these citizenships to Palestinians abroad, the Palestinian refugees, in order to create some sort of facts on the ground that these are citizens now, and now they can come back to Palestine. Would that detract from the right to go back to their home? As since the Palestinian statehood right now in international law is basically in the Palestinian occupied territories, West Bank, Gaza, and West Bank, including Jerusalem, of course. So would that detract from the right to go back to their homes, according to the right in international law, that they are not just entitled to go back to Palestine as a state, they are entitled to go back to their own homes, whether it might be in Haifa, might be in Yafa, might be in any city in Palestine before Israel existed. So I would like to pose this question to both Lex and Francesca. Thank you.
Great question, Hassan. Hiba? If Hiba is with us, Hiba?
Hi, thank you so much. Thank you so much for both Lex and Francesca for accepting Law for Palestine's invitation today and speaking on this crucial matter. And thank you for the great lecture that you just presented. My question here is a little bit related to what Hassan asked. So now we can't separate the demand for the right of return from the final determination of Israel's national identity. In light of the international expanded definition of anti-Semitism, how can the Palestinian right of return focus as a vehicle to change this character, especially if we mean that Palestinians can go back to their original cities and villages that they left behind? That was my question. Thank you so much.
Thank you, Hiba. Maybe you can take another question if there is another person who would like to ask. Okay, so we'll give the floor again to Lex and Francesca. Maybe we start with Francesca because I asked the first question to Francesca.
Yes, you all asked questions that would require entire webinars to be answered, but because you gave me a few minutes, I will try to be brief. So on the first question, ICC, before going to that, you mentioned, Mutaz, in the case of Palestine, there has always been a problem of enforcement. I couldn't agree more, because in fact, we argue that international law has always been on the side of the Palestinians since the very beginning, but this is something that has somewhat got lost in the advocacy over time, and this is why it's important to reaffirm it today. The fact, for example, that the right to return was already established, an established principle of international law in 1947, because it allows to counter the argument that often comes from Israeli pundits and others that, well, I'm sorry, yes, now there is the right of return, but it didn't exist back in 1948, too bad. So I also, so having said that, I also think that it's true that international law, as Victor Catan says, is closer to politics than to justice in the Middle East. But this is not an immutable state of affairs. It can be changed. And I do believe in legal advocacy and legal work in order to undo the perverse effect of politics. And I think that the ICC is an eminent case in this respect, because look at already the kind of it's scary, the fact that there can be arrest warrants issued by the ICC and then have effect in every country which has ratified the Rome Statute and beyond, is a cause of concern for Israel. So I do see, although it might take time, I have no illusion, I do see the ICC investigation as carrying enormous potential. And to answer your question, how this can benefit Palestinian refugees. Here we close the circle with what I said in the beginning. Legal advocacy and legal research is fundamental. There is a precedent in the ICC work itself, in the case that was brought recently to our attention in Myanmar, where the denial of the right of return is considered as a crime under the jurisdiction of the court. So this is a case, if lawyers manage to argue this, linking it to the settlement enterprise, and personally, this is something with which I'm struggling since I started working with Lex on the book, the theory of the continuous violation doctrine is a powerful argument. It has been used in the case of refugees only once, to my knowledge, in the Loizidu case by the European Court of Human Rights. Other than that, it has only found application in cases of enforced disappearances. But if there are legal minds at work which try to argue how the settlement enterprise can be seen as a continuous violation that started at the time of the Ottoman Empire, and the rights of the refugees have been violated in the execution of that plan. I mean, again, this is what I'm throwing out here are ideas that could be used to make a case that also helps the recognition of the rights of Palestinian refugees. Although, again, as I said, they're already established in international law. And concerning the other question, sorry.
Palestinian nationality, Palestinian citizenship, granting Palestinian citizenship.
Yes, sorry. The granting yes, I'm familiar with that argument. Actually, you, Mutaz, are the expert on citizenship, so I think that you are best placed than I in answering that question. But my knowledge of the issue is citizenship is a bond between an individual and a state. I'm not questioning here if Palestine is a state or not. It is a state, but the problem is that it's a state under occupation. It was born under captivity. It has never exercised the sovereignty other than the paraphernalia of it. And so how can it ensure protection to its citizens if it can't even grant them entering and exiting the territory? So my question would be is worth investing on something that it would be of nominal value, because outside Palestine, they are entitled to protection as refugees, through protection as stateless person. It's struggling. I mean, it's enormous effort that is taken to ensure that kind of protection. I'm not sure personally, Mutaz is better qualified than me to argue in this respect, what, under a context of a settler colonial paradigm, which trap the state of Palestine, what the recognition of citizenship could bring. I'm personally doubtful, but I would stop here.
I will say a few words on this after listening to Lex. Lex, please go ahead.
Thank you, Mutaz. Thank you, Francesca. Before answering your question, Mutaz, on sort of the resumption of US funding and sort of calls for reform, just a footnote on the issue of sort of enforcement. In a number of our online webinar, this question has come up, and it has reminded me of what my professor of international law used to tell us students, young students in international law in the late 1970s. He said, you know, listen, students, you have witnessed the era of the codification of international law, in particular the whole international human rights regime and the refugee regime. And it's now incumbent on you guys in the 21st century to seek the enforcement of that regime. You know, it is your job to work towards, you know, giving international law teeth and enabling it to be really implemented and have an impact in holding violators to account. And it's always something that has been in my mind, and I'm telling it now. There are so many young lawyers. You know, this is the challenge of the century, to strengthen international law in terms of accountability. And it's just hard work. It's legal work, it's political work, it's advocacy, it's raising awareness, and so forth. Then, yes, indeed, very happy to hear the news about the US resumption of funding to UNRWA. So far, 150 million. Before the Trump cuts, the US used to contribute about 360 million per year. So we hope that this is the beginning of, or this is the first contribution by the US this year. And yes, the US and other donors are from time to time raising concerns about sort of reforming UNRWA. Part of this is to sort of appease their, you know, in the US, critical voices in the US Congress, you know, for the State Department to keep the critics at bay. UNRWA is an organization that has gone through enormous reforms over the years, and it has been in many ways a very modern, forward-looking, empowering organization since the 1950 onwards, well before sort of notions of promoting human development were introduced in sort of the international development discourse. UNRWA was already promoting the human development of refugees through education, through supporting their healthcare, through selective relief and social services, through microfinance, through infrastructure interventions. So UNRWA has been a very sort of advanced and sort of modern, ahead of its time organization. And as a result of the recurrent financial crisis, it has made tremendous efforts to sort of reform towards more effective delivery of services and to adopt modern sort of management practices. So really a lot has happened over the years. And UNRWA, I strongly believe, I mean, I'm I'm no longer part of UNRWA, but I still strongly believe that UNRWA is one of the most effective UN mechanisms in delivering sort of key public services. The quality, the ratio of the quality versus cost of UNRWA's primary health service model is unprecedented, for example. And the same goes for the education. In terms of reforms, yes, there is further scope for reforms, and as part of the suggestion to develop this comprehensive framework that would reinitiate a discourse on solutions. We also believe that a reflection by UNRWA of the way it has interpreted its mandate over the 7 decades of its existence is called for. When the Conciliation Commission in the mid-1960s stopped functioning, the effect was that there was a sort of a void with respect to an institutional arrangement advocating for durable solutions for Palestinian refugees. And this void has never been addressed. And we believe that this is, an area where UNRWA itself should sort of step in and reflect on its mandate. We also feel that UNRWA has made important developments in sort of including protection as part of its mandate, but we believe there is much more to go in this domain, and we particularly also believe that it's important that the protection somehow also extend to the historic rights and claims of the Palestinian refugees, and especially in terms of making sure it becomes and is seen as a repository of all the historic documentation pertaining to the refugees' exile. UNRWA holds millions of documents that were over the years provided by the refugees, documenting elements of their very rich various facets and aspects of their exile. And then I mentioned earlier that the Conciliation Commission for Palestine has between 1950 and 65 meticulously documented all the property losses by the Palestinians. This is in the greatest detail. There are even forms documenting individual olive trees. It is so impressive. And that work is being digitized. And with the increasing digitization, it is only a matter of time before these two sets of records can be linked. And UNRWA is already working on making sure, recognizing the responsibility it has towards the refugees, is to also provide an interactive portal so that all Palestinian refugees around the world can seek access, digital access to their family records, including eventually to the linked property documents. And if that happens, we have a very valuable repository that will be able to help you young lawyers in the next decade to pursue claims for compensation, claims for return, claims for restitution. So that's very important work. And I think that's also what refugees expect from UNRWA. Over a decade ago, a very important survey was conducted by UNRWA together with the Graduate Institute of Development Study in Geneva amongst Palestinian refugees in all the 5 fields of UNRWA operation. And one of the questions related to, what is, for you refugees, what is important of being sort of registered with UNRWA? And what is the most important? Is it the services that UNRWA provides? Is it the confirmation of your status? And there were 2 or 3 other entries. And it was interesting that at that time, we speak about 2006, it was only the refugees in Gaza that said the services is the most important thing. all other refugees answered that, you know, the confirmation of their status, in other words, their unresolved historic claims, and UNRWA needs to be more responsive to that demand of the refugees, and I believe that's you know, a key area for reform. So I'll leave it at that because I'm taking more time.
Thank you, Francesca and Alex. We have another 3 requests for questions, but before giving them the floor, I will just try to say a few words about Hassan's question. The question of Palestinian nationality is very, I would say, complex. You know, I have done several books and articles about the question of Palestinian nationality, starting from the end of the Ottoman Empire until today. The most recent one, an article published in a form of a draft law that I proposed to the Palestinian state, or the state of Palestine, is to grant a Palestinian nationality to all Palestinians who wish to acquire that citizenship or nationality. Because as Lex indicated, you know, UNRWA still is not providing proper protection to Palestinian refugees, and there are many Palestinian refugees across the world who are stateless and have no one to protect them or provide them with diplomatic protection. Giving or granting them Palestinian citizenship, regardless of their return, even to the state of Palestine, to the West Bank and Gaza Strip, would be a documentation for them, or a basis for them to claim protection vis-a-vis host countries. But I understand some concern that Francesca hinted to. The question is very complex and needs much discussion before adopting that law. But I would also say that this question, the question of having a law regarding Palestinian citizenship, has been proposed by the President Office and by late Dr. Saeb Barakat, who commissioned me to draft that law, in the potential that the state of Palestine might grant this citizenship in order to form a Palestinian people. As we know, every state should be composed of a territory, land, government, and people. And the citizenship or nationality is the bond that connects or links people with the state. So it's important to have that law of citizenship. But as also I discussed with Ihsan, we might have another event dedicated to this issue, because it's very big issue. I wrote about 6-7 articles on this, including my PhD, which is converted into a book. You know, Francesca wanted to say something.
Yes,
if you may allow me,
Francesca,
yeah. Just for the sake of time, I will give you the
no problem.
Time to answer, but just let us take the other 3 questions, or maybe take all questions together, and then give you the possibility to answer as you wish.
No problem.
Iman Zayater wanted to say something. Iman?
Hi everyone. Thank you, Mutaz, Lex, and Francesca, for this very enlightening remarks on this very important issue on under-researched. So my question is, as I understood from the book, that you call for some type of strategic integration, cooperation between UNRWA and UNHCR and what they provide for Palestinians, especially in terms of protection from UNHCR. So I wanted to ask, like, is it possible for UNHCR to provide anything more for Palestinians than what UNRWA is already providing them? And especially that the 3 durable solutions that UNHCR can provide doesn't seem to be really working for Palestinian case. Or it's moving to UNHCR is only to jeopardize their right to return, and the right of the future generations to be recognized as refugees. So yeah, that's my question. Like, is there anything else that UNHCR can provide for Palestinians than what UNRWA is already providing? Thank you.
Thank you, Iman. Just also to add maybe just a footnote on what Iman said. You know, possibility of UNHCR to jump or take over or give some protection to Palestinian refugees, where even in certain areas of operation for UNRWA, for example, Palestinian non-IDs, so-called non-IDs residing in Lebanon who are not protected either by UNRWA or by any other agency. How UNHCR or would UNHCR would have the possibility to provide certain protection to these refugees. Karim Asaf, Karim, please go ahead. Karim, تفضل.
Hello. Many solutions has been put forward to the Palestinian refugee problem, including accommodating refugees in Arab countries or foreign countries, and a lot of other solutions, of course. My question is, based on current circumstances, what is the most realistic solution to the refugee problem?
Thank you, Karim. شيماء خليل، تفضلي شيماء.
يعطيكم العافية جميعا.
تفضلي.
هلا أنا عندي شكرا على الكتاب صحيح وشكرا على الملاحظات اللي أعطيتونا إياها. عندي بس كمان استفسار أو أسئلة تراودتني وخلال أنا قرأت للكتاب لاحظت بس كمان سؤال. السؤال الأول اللي بدي أطرحه إذا كان اللاجئ طبعا اللاجئ الفلسطيني بخصوصيته إذا كان اللاجئ القادم من غزة ومسجل لدى الأونروا في غزة قدم للأردن هل بيستفيد من مساعدات الأونروا أو لا؟ هذا أول سؤال.
Okay, the first question let me خليني بس أحاول أترجم الأسئلة سؤال لأنه أنا بديش أتذكرش كل الأسئلة. السؤال الأول the first question Francesca and Bex regarding those refugees who move from one area of operation of UNRWA to another area of operation and brought the example of refugees who move from Gaza, for example, to Jordan. Would they benefit from UNRWA assistance or protection?
تمام. هسه السؤال الثاني اللي بيتعلق برضه بالخصوصية اللاجئ الفلسطيني الواقع مع غزة اللي هو إذا كان اللاجئ الفلسطيني المسجل في غزة ولجأ للأردن هل بيكون محمي من الطرد؟ بما أن إحنا طرحنا موضوع الطرد وحكينا أنه يجب أن نوفر حماية للاجئ الفلسطيني من عملية الطرد. هل بهي الحالة تم حماية اللاجئ الفلسطيني من عملية الطرد أو لا؟ آخر سؤال بس بدي أسأله.
خليني أترجم شيماء لو سمحتي. Shema is continuing her first question regarding the Gazans in other countries, particularly in Jordan. Would they be protected against no-refoulement or the forced return to Gaza?
اسال اخر سؤال معكم بس عشان انا شوي بقطع. اخر سؤال بس
تفضلي.
تمام. اخر سؤال بدي اطرحه اللي في عام 1967 تم منح وثائق للاجئين الفلسطينيين. هاي في حاله اللاجئ الفلسطيني خرج من المنطقه اللي كان مسجل فيها هل هاي الوثائق بتحمي اللاجئ الفلسطيني من الرجوع للبلد اللي كانت معطيته هاي الوثائق ام لا؟
Another related question regarding those refugees who acquired documentation from UNRWA after the 1967 war. Many of them they were granted documentation or registration with UNRWA. Would such documents be good basis or would be valid for their return, not to Palestine of course, but to the places of UNRWA operations from where they were displaced? And maybe here she's hinting or indicating those refugees who left Jordan after the what called Black September, when many of them they left to Lebanon. Would they be able, for example, to return to Jordan? Okay, let's see if others would like to ask questions. If not, we'll give the.
I think Dr. Huda, maybe the last question. Dr. Mutaz, Dr. Huda is raising her hand.
Okay. Please, Dr. Huda, go ahead.
يسعد مساكم يعطيكم ألف عافية.
تفضلي.
شكرا. والله لو سمحت أنا حابة أحكي عن الفلسطينيين الموجودين بتونس واللي طلعوا من بيروت واجوا على تونس بمقتضى اتفاقية. شو وضعهم القانوني؟ هل هم لاجئين مش لاجئين؟ بالإضافة إلى ذلك شو هي حقوقهم؟ هلا نحن كفلسطينيين مثلا موجودين بتونس ما عندناش أونروا، ما عندناش حقوق مدنية، يعني أنا مثلا ما عنديش حق العمل في تونس، ما عنديش حق التملك. كيف ممكن إنه نحن نقر حقوق للفلسطينيين مثلا الموجودين بتونس؟ شو وضعهم القانوني؟ شو هي تسميتهم بالقانون الدولي؟ لأنه أنا صراحة حاولت أدور على الموضوع ما لقيتش حل، إنه نحن شو تسميتنا وكيف ممكن نتحصل على حقوقنا المدنية. وشكرا كثير لكم.
شكرا دكتورة هدى. يعني بلاحظ شوية لهجتك الفلسطينية وشوية هيك فيها شوية تونسية كمان. هدى's question is regarding
تأثرنا.
أول مرة بشوف حدا فلسطيني صراحة، يعني من اللاجئين الفلسطينيين في تونس. أكيد في كثير فلسطينيين في تونس، بس
عندنا كثير.
سؤالك كثير مهم. Huda is asking very interesting question regarding those Palestinians who left some areas of UNRWA operations, particularly those who left Lebanon probably in 1982, who live currently live in Tunisia. So what would be their status? Because it's not clear to her and neither to me. What would be their status? Of course, we know that UNHCR might have jurisdiction or mandate regarding them. But what if you came across their status, Francesca and Bex?
Yeah.
Probably.
Can I start, Francesca, and then you compliment me?
Okay. Yeah.
Okay.
I will just take the solutions bit, and the cooperation between UNHCR and UNRWA, and you can complement as you deem appropriate. In terms of yes, we describe in the book the cooperation between UNHCR and UNRWA, and indicated that it has become more strategic. What we're advocating is not that UNHCR take over, but that there is sort of a seamless continuity of protection, as we call it, with respect to the support and protection provided by UNRWA in its area of operations, and by UNHCR with respect to those Palestinian refugees who are outside UNRWA's area of operation. So that, you know, if refugees from UNRWA's area of operation leave the area, that there is no gap, that UNHCR is sort of seamlessly taking over the protection role. In terms of the non-ID Palestinians, for example, in Lebanon that you mentioned, Mutaz, we're not suggesting that UNHCR would have much to offer. It's rather for UNRWA to sort of expand its protection role to also include such people. And UNRWA has actually done that, has extended both assistance and a measure of protection to non-ID Palestinians in Lebanon. Then the solution question, what is the most realistic solution that we see? What we believe is that in terms of solutions, what is critical is that firstly the refugees have freedom to choose whatever solution is most appropriate for their situation. You know, we're not in 1948, we are now 70 years later. As Francesca has described, refugees, Palestinians are dispersed over more than 50 countries. And so it is important for them to access and to choose what fits for them. What we believe is important is that, like all other refugees, all solutions are on the table. And we're trying, and we have made it clear, and we've mentioned it several times in the presentation. If a refugee would choose to seek naturalization, or to seek resettlement in a certain country, or to seek integration in a certain country, this ends the refugee status, but it does not end the right of return and the historic claim to return to Palestine, to original homes, to restitution of those original homes and compensation. So a maximum choice, the full palette of options, like they're open to all other refugees. We believe that that would do most justice to the Palestinian refugees as well.
Yeah, but just to clarify something, the acquisition of a new nationality would end the refugee status in the sense that they would not get services and protection, and they would not even need for that service of or protection.
Because they have national protection.
Or from UNHCR. Yes. But their status as refugees in terms of right of return and restitution and compensation, that is something that is covered by other branches or fields of international law.
Yeah,
correct.
Absolutely. Absolutely. And there has been often a confusion about this. For many years, refugees were sort of discouraged from naturalizing, discouraged from seeking asylum, because it was seen as jeopardizing their right of return. And this is a falsehood. This is a misperception that we try to correct.
Yeah, I tell any refugee, just if you had the possibility of acquiring any nationality that improves your situation, go ahead and take it, and that it will not legally affect your right of return. This is I say.
Absolutely.
I can put it on my shoulder, and I take responsibility for that.
Exactly. The Palestinian refugees in Jordan, who have Jordanian citizenship, are as much entitled to return and to restitution and to compensation as the Palestinian refugees who are stateless in other parts of the world.
And even those in Jordan, they would not, their refugee status in terms of UNRWA services would not even end. They still continue getting.
Exactly. That has a different.
Because
that has a special historic reason. Yeah.
Yes. Actually, just
let me
completing a paper called the next specialist for Palestinian refugees. I don't want to take your time. Francesca, please go ahead.
No, please. No. I was just, because it's all coming together, and it gives us an opportunity to also add another element to what Hassan was asking. Because it's going back to the question of politicization. International law has not been fully used for the Palestinians and by the Palestinians themselves, including because especially in Arab world, they've been held hostage by what anthropologist Neil Gabian calls the politics of suffering. And we still see this today, this argument, no, you cannot apply for nationality, otherwise you will lose the right of return. It applies today as well. When you have tens of refugees, if not hundreds of refugees from Lebanon, becoming both refugees because they have no other way. They are discriminated and not given any possibility to pursue a life, to have a future, and they can't even apply for resettlement because they are told, no, you cannot do that because this is precluded to you. So this is the politicization of the Palestinian question that we see it repeating over and over. And now in completing what Lex, actually I'm glad Lex took the lead, because it allows me to take a step back and say the cooperation that we call for in the book between UNRWA and UNHCR is not our invention. It's an emanation of the very spirit of the 1951 Convention, Article 1D, which, as UNHCR interprets, and actually Mutaz and I are writing a new commentary on Article 1D of the 1951 Convention that will be published soon, and we clarify this as we do in the book. That article, with the reference to the special arrangements that existed for Palestinian refugees without excluding the competence of UNHCR implicitly, explains what is the continuity of protection, which is interpreted today in very simple words. If Palestinian refugees are international refugees, if they are in UNRWA's areas of operation and UNCCP, let's not forget, Article 1D refers to UNCCP and UNRWA, not just to UNRWA. But So if in this area of operation, protection and assistance if protection and assistance by this agency ceases for any reason and they find outside of this area, they're entitled, for objective reasons, they're entitled to the protection of UNHCR. Now, our argument is that instead of thinking who does what, UNHCR and UNRWA should strengthen their cooperation in order to determine what is needed by the Palestinian refugees wherever they are. And if it's true that those in UNRWA's areas of operation are responsibility of UNRWA, then UNRWA should deliver what international protection means. 70 years ago, it was not needed. 50 years ago, Arab states were still very benevolent toward Palestinian refugees. The discrimination that we see today didn't exist 50 years ago, but now it's the reality. So why shouldn't there be a change in the way even UNRWA delivers its mandate? So protection is a necessity and doesn't require a change of mandate, requires honesty in applying international law. Now, going to the question of whether, because then you see the problem, can a refugee from, very specific question, can a refugee from Gaza go to Jordan and get protection? I would say it depends, because the fact that UNRWA operates in these in the areas where it exists doesn't mean that it has its sovereign. It's not a sovereign state. It's still Jordan which decides who enters, who are the rights to legally stay, what are the entitlements, and and so on and so forth. No Palestinians other than those who received citizenship in until 1954 are considered fully protected in Jordan. And this includes all the 1967 displaced and everyone who comes from Gaza. So in our experience, this is not certain. The existence of UNRWA is by no means certainty for protection. Does this mean that Palestinian refugees, this is very actual. I mean, what we are discussing, it's what's happening today in Europe. There are Palestinian refugees who flee UNRWA's areas of operation, seeking refuge in Europe. And you have states saying, sorry, you are a Palestinian citizen, so you are protected by Palestine, or say, sorry, you should go back to UNRWA's areas of operation because this is where you are protected. And now the Court of Justice of the European Union is developing this jurisprudence which says, wait a second, it's true that if the person has removed him or herself from the territory where UNRWA operates, probably protection cannot be considered seized. But if there is no possibility to return to Gaza, and this is what the court has recently established, because Gaza is not a livable place, the refugee has the right to get full refugee status in Europe, not subsidiary protection. And having said that, let me add that everyone has the right not to be, to benefit from non-refoulement. So everyone who arrives seeking asylum in a country should be given the opportunity to claim asylum if they want so. And so this is a principle, a general principle of international law. There is another point concerning the interesting case of the Palestinians who are displaced from Lebanon to Tunisia. Where shall they go? So my take, and this is open, for debate, but the point is that if there is international protection means that the refugee, if he or she is born in a country which has ratified, for example, the Convention on the Rights of the Child, which stipulates that the state is obliged to give nationality to a child who would otherwise be stateless, then the person should have the opportunity to apply for citizenship. And as Mutaz was reinforcing, this would provoke a cessation of refugee status under the 1951 Convention, which means no protection from UNHCR, but doesn't exhaust the rights Palestinians are entitled to. As a citizen, you have the opportunity to become a critical mass and influence processes that might possibly lead to greater justice for the case of Palestine. If the person in Tunis doesn't want to apply for citizenship, can apply for refugee status. Now, Tunisia has ratified the 1951 convention, and there it comes. It does. Many Palestinian refugees have not been able to be recognized as refugees because there is often this misconception that they are not refugees under the 1951 convention, or they should go back and be protected by UNRWA. This is why it's so important to provoke a debate and to have a better narrative and more fact and legal-based knowledge on the rights of Palestinian refugees.
Okay, we should conclude and stop now because our interpreters are exhausted, because the interpretation is very demanding and takes lots of energy. Exhausting, yes. We should have should stop.
Thank you to them.
By the end, I would like to thank you very much, Lex, for this opportunity. And thank Francesca also, and we hope we will meet again to discuss other issues pertaining to Palestinian refugees and probably Palestinian nationality and other issues. It was really great. We appreciate that very much. I would like also to thank all those who were with us this afternoon or this evening or this night or this morning. Those jurists for Palestine who were with us by Zoom. Those who asked questions. I would like also to thank very much the organizers, Hassan Adil and his team, excellent team. And I would like also to apologize for some technical interruptions of the internet. It seems that there is a problem in general in the globe because we have some issues in Jakarta and here in Jerusalem and probably in other places. But this is the reality of the technology. But still, we managed to say what we wanted to say at this webinar. Finally, I would like to thank our interpreters for their excellent work, Noor Haqqi wa Malik Diraniye. And yes, thank you very much, and see you again somewhere else soon. And bye-bye.
Thank you very much. Bye-bye, everyone. And thank you for that, Tarjuma.
Bye-bye.
Bye.
Thank you.